Now let's talk about New York State medical malpractice law. As I just mentioned, there is essentially a 2.5 year statute of limitation, and in general, there is no discovery rule. Most states have a discovery rule where you have a certain amount of time from when you discovered the malpractice. New York State does not. It's one of about 5 states that doesn't. So in other words, if you haven't found out about the malpractice during that 2.5 year period of time, you're pretty much out of luck. There are exceptions, of course, which we'll get to in a minute. Now, in 1975, the statute of limitations was reduced from 3 years to 2.5 years, which frankly is kind of an oddball number, but apparently the medical community in New York State had a pretty powerful lobby to get them to reduce it by 6 months. Obviously, that was a good deal for doctors and a pretty bad deal for patients. But like any rule, there are exceptions. As a matter of fact, recently the state of New York passed a discovery rule when cancer is involved, because many times, if that's misdiagnosed, you don't know years later till you had it. So they're allowing for a discovery rule in that case, but that is only recent. However, there are other exceptions. One is if a foreign object is left in a patient after an operation, such as a scalpel or a sponge, and it isn't discovered till much later, well, then the statute of limitations is told. There is another exception, however, and this has to do with the doctor's fiduciary obligation towards his patient. It is an established legal fact that a doctor has a fiduciary obligation to put his patient's welfare before his own. In other words, if the doctor commits medical malpractice and is aware that he has done so, he must inform the patient of the malpractice so that the patient can correct the medical problem and initiate a timely lawsuit against the doctor to recover compensation and/or damages. If the doctor fails to inform the patient of the malpractice and tries to cover it up by fraudulently concealing or misleading the patient in order to run the clock out on the 2.5 year statute of limitations, the doctor can no longer hide behind the 2.5 year statute of limitations, and as a matter of fact, the statute of limitations is told for 6 years past the date of discovery of the fraud, which in this case would be the malpractice. Critical case law in this area was established in 1978 in the landmark case of Sukumsky versus Sayeli. This is a critical decision in the state of New York, which is used not just in medical malpractice cases, but this is cited in fraud cases all over the place in the state of New York. In that particular case, Dr. Sayeli operated on Mrs. Sukumsky, I believe, in 1970. He performed some sort of operation on her face or neck, and during the surgery, he accidentally severed a nerve, and he was aware of what he had done. After the operation, Mrs. Sukumsky told Dr. Sayeli she was having numbness in the area, and he told her, instead of being honest with her and telling her what happened, he told her that she needed physical therapy and various other treatments, and eventually it would clear up, which was a blatant lie. Well, this apparently went on for approximately 4 years. Finally, after 4 years of no improvement, Mrs. Sukumsky got a second opinion, and that's when it was discovered that the nerve had been cut. So she found an attorney who filed a lawsuit against Dr. Sayeli. Well, the discovery of this was 4 years after the operation, and she hadn't seen him apparently in all those years, and the statute of limitations at that time was 3 years past the date of last appointment. So what was Dr. Sayeli's defense? Well, the statute of limitations expired, of course. It had expired 1 year prior and was time barred. The trial judge apparently agreed with that assessment. So her attorney filed an appeal. And it turns out the New York State Court of Appeals reversed and said that there was more than enough evidence to indicate that Dr. Sayeli knew exactly what he had done, and instead of informing the patient of what he had done, he tried to cover it up and mislead her for all those years, and therefore the case was not time barred, and it was sent back to the trial judge. They also determined that the statute of limitation was told for 6 years past the date of discovery of the fraud, which in this case would be the malpractice. So this is obviously a very powerful piece of case law that benefits patients who have not been to the doctor in the last 2.5 years when the doctor is fraudulently concealing his own malpractice.